Hello, good evening, everyone. Welcome once again to one of and today we have Dr. Charu Mathur with us. She's an AOR with Supreme Court of India, and in the course, she'll be taking some of the elementary classes as well as classes from IBC, mostly through the insolvency law. So I welcome everyone.
Good evening, everyone. I am Dr. Charu Mathur. I am an advocate on record with the Supreme Court of India, and I will be taking parts of the company law, parts of the IBC in our Upskill course, which EBC Learning and CII have tried out. Now, as you know, today what we are trying to do is we are going to explore your pre-packs. So allow me to share my screen with you. So as you are aware that during the pandemic, there have lot many changes that has been brought into IBC, or Insolvency and Bankruptcy Code. Now, one of the major changes that has been brought is uh, is relating to the change in the threshold. So as you know, initially the threshold was 1 lakh rupee was the default threshold, and now it has been increased to 1 crore rupees. Now, if you look at it, it is actually a double-edged sword. At one place, it was shielding the corporate data from any sort of that there should not be any insolvency. They should not be pushed into things like insolvency because of pandemic. But at the same time, if you look at the other side of the picture, the people who wanted to recover their amounts from the various companies, they could not also initiate CIRP, and this was especially tough for small, medium, and micro enterprises. It was extremely tough. First, they were not able to meet the threshold of 1 crore rupees, which was the new threshold for default. So, government on 4th of April 2021, it came out with an ordinance proposing pre-packs or pre-package insolvency, which we call pre-packs. And on 9th April, it was notified, IBBI notified various rules, etc. Now, if you look at the pre-packs, why is it so important for our MSMEs, right? If you look at the structure, if you look at the contribution that MSMEs make to our economy, then it is huge. But if you look at the resolution, then there are very few effective options that are available to the company for the resolution of the stressed companies. So you have got two things. You have a formal via either you can go under CIRP under IBC, or you can go under scheme of compromise or arrangement under the Companies Act. The another way is that of the informal route, that is out of court settlement. So for this, you have got RBI's prudential framework for resolution of stressed asset, and the second is you have an informal dialogue between the creditor and debtor with or without the help of a mediator. Now, each one of these had a pros. I mean, like anything else, they had their own pros and cons. So as far as your CIRP is concerned, you know, CIRP is a long drawn process. It is a process which requires lot of cost is involved, lot of creditors are involved, and then if it is not, you ultimately lose out on your company, right? All the management of the company, it goes from the board of directors to the resolution professional. So you are an outsider in your own company, right? And when the default was even 1 lakh rupees, the earlier default, everybody was taking the company. So instead of meeting the objectives of the IBC, that is to maximize the value of the assets of the corporate debtor, it was started being used as a route for recovery. So the government, in its wisdom, has come out with something known as pre-packs. Pre-packs are available throughout the world. It is available in France, Singapore. It is available in your US, UK, all the advanced jurisdiction. So, what does this pre-packs mean? Pre-pack, as you can guess from the name itself, right? It is already packaged. The solution is packaged to you. It is pre-packed. So this is the solution that I am offering to you. So in this case, CIRP under IBC, as you know, is a creditor centric mechanism. Earlier in the SICA, it was that debtor was in possession. Once you go into BIFR, not even God can trouble you. If you get a decision in your favor from AIFR, then you are set for life. Nobody will come. You keep on defaulting, you make your companies NPA, your banks will not be able to resolve the debt, the loans that they had given. As a result, IBC was brought into, there were dirty dozens, and finally the resolution has to begin. Initially, when CIRP started, there were haircuts as long as 50-54%, 60-64%. But of late, CIRP has proved to be quite effective, and lot many debts have been resolved. There is now, after almost, it came in December of 2016 when it NCLT became effective. So even if you count from that time, so even in 5 years, we have a good body of jurisprudence where there were many lacunas in the legislation, many were tweaked, and it is a good source of legislation. At least some money is coming back into the system and it is circulating, and people are getting the companies which are under distress, which are having the bad management, they have to lose it and they have to give to some other company. Now, as far as this PIRP is concerned, or PPIRP, whichever way you want to call it. So, in this case, for MSMEs, before this amendment was brought, before this ordinance was brought, and then subsequent amendment and rules and regulation was there was no effective remedy available at that point of time. So the government, in its wisdom, thought to bring it. So by this ordinance, which eventually turned into the act, a new chapter, chapter 3A, has been inserted into the Insolvency and Bankruptcy Code of India. So as far as Insolvency and Bankruptcy Code of India is concerned, what it has done for the MSME sector is that it has inserted chapter 3A. It contains almost 16 sections are there, and it provides you for the mechanism for resolving the debts of a MSME. Now, before I start with what all it does, it is imperative for me to tell you what are the salient features of PIRP.
Dr. Charu, just to interrupt for a second, in chat box, you can see questions. So Mr. Bala Subramaniam has asked, what is PPIRP?
I can't see any question from them. I can only see from you.
You can go bottom corner, you can see the chat. You can click on the chat and the chat will open.
हाँ chat में I can see only inbox. अच्छा, okay, in the
Oh,
room.
room. Yeah, you have to
Sorry,
go to
sorry,
room.
sorry, my mistake. So,
Yeah.
Mr. Balasubramaniam, I'm sorry I didn't see that. PPIRP means pre-package insolvency resolution process, or some people call it simply PIRP. Like for corporate data, for you have for the corporate resolution, you have CIRP. So here some people prefer to call it PIRP or PPIRP. So here I have chosen to call it PPIRP. That is, P stands for pre, another P is for package insolvency resolution process. So PPIRP is the mechanism which is provided for resolution of insolvency of MSMEs. Now, as far as India is concerned, right now it is applicable only to MSME. Now, as far as this act is concerned, as I have told you, Chapter 3A has been added. So, PIRP or PPIRP is available only for MSMEs. Now, who is an MSME? To be an MSME, you have to be registered under the Section 7(1) of MSME Act. Now, under this, PIRP, the salient feature is, and it is very important, that it is the debtor who remains in the possession. Powers of board of directors is not suspended. Unlike in CIRP, when you go for corporate insolvency resolution process, then your the board is suspended and the interim resolution professional is the one who becomes whole and soul of the company. Then, keeping the corporate data as a going concern is not the duty of the resolution professional, but it is a duty of the board of directors. So, because it is the board of directors in case of PIRP who are in control, so the duty is casted on them. Thereafter, the protection and preservation of the assets is not again a duty of resolution professional, but it is a duty of the board of directors. And one thing that you need to understand about PIRP is it is not a coercive step. Nobody is forcing you to go into the this type of resolution, but it is a mutual one, right? Here it is the one where debtor and creditor, they come on the table, they say that this is a problem, we need to resolve it. So it is not coercive, it is a mutual one. It is an effort which is made to ensure that it is an effort that is made to ensure that the stress of the financial stress of the company is resolved. Now, as compared to CIRP, this is a shorter process. This is a process of only 120 days. Either you resolve or let us see what can be done. It is cost effective. It is the least disrupted form of resolution of a debt. Of all the processes, whether it is compromise, whether it is through CIRP, or even if it is through the court mediation or RBI framework is there, of all the measures, the PIRP is the simplest one. It is the simplest one as it offers the solution which is mutual. It is one which is hybrid in nature. It is hybrid in nature because it takes the best of both the worlds. So there is a part process which is formal, there is another part of the process which is informal. As we will go in our insolvency course, in our upskill course, I will be telling you in more detail about how the PIRP works, how you actually go about it. Now, coming on to the further aspect, PIRP, it preserves the job. There is no liquidation under PIRP. And if it is not successful, then nothing happens except that you go on your old ways and then you try to figure out how best it can be taken into consideration. Now, if you look at how to implement this, now you must remember that this is available only to companies and LLPs, plus those companies and LLPs which are registered under MSME Act. Further, the default has to be of 10 lakh rupees. There is no upper limit provided as such, right? But by a subsequent notification, this was raised at between 10 lakhs to 1 crore. You should use this PIRP method. Another important thing that you need to remember is that by the virtue of section 10A of the IBC, there was a certain period from 24th March 2022 to 25th March 2021. If there is any default, you cannot initiate CIRP. But that exception has been carved for MSMEs. PIRP give you option to even to recover debt which has incurred during this period. Now with this, let us look into the other aspects of PIRP. Now, as far as your PIRP is concerned, I have told you already that it is a hybrid of of your formal and informal procedure. So, uh, in this case, there are various options which parties can come with which parties can decide how to go about it. So, in this quicker process, there is no concept of IRP, as you must have noticed that I have not used the word IRP. There is only RP, and once there is consent of the financial creditors for appointment of resolution professional, so there is no need to change for RP until and unless committee of creditors decides to go for the same. Now, coming on to the further aspect, you need to understand one very important thing. It is the company, the corporate debtor, which actually comes with something known as BRP or baseline or base resolution plan. So, this is the base, and after that, you can go on better plans. There are two type of plans which I will be talking to you in the course, where they compete. So it is not the outsiders who are competing, it is the creditor and the debtors who are competing to get the best out of it. Now I'll quickly give you the timelines which are available. So first is the phase A in this. In the phase A, there has to be preparation and filing of PIRP. So this is a time period is given as 90 days. So within in 90 days, the RP he sits, and before that actually you have to sit with your lawyers, you have to sit with your chartered accountants, and you have to actually see that who all are the creditors, because the first resolution plan under the IRP is the base resolution plan, and it is the one which is formulated by the RP himself, by the corporate debtor himself. And once it is the committee of creditors doesn't find it to be in conformation with the waterfall mechanism remains the same for CIRP as well as for IRP. Then there are certain implication. You can improve, you can give a better plan, you can give a superior plan, that we will come later in the course. Now if you move on to the phase B of the PIRP, in the phase B of the PIRP, in the phase B, the plan is put before the NCLT, before in fact the COC, and they can either accept or they can reject it. They are given a 30 days to do so. So if it is accepted, fine. If it is rejected, then the company will be given a chance to give a better resolution plan. But if it fails to do so, then in such a case, I think there is sorry, Prithviraj, COC is Committee of Creditors. I'm so sorry because we're teaching IBC and doing IBC. I've got so used to using these acronyms. So you have done the right thing to stop me right here and tell you. So you know what is a COC? COC or Committee of Creditors is the committee which is formed by the financial creditor of a corporate debtor. So the company which is in the stress is known as CD or corporate debtor. So once the company is engaged as a corporate debtor, so the in the CIRP, that is Corporate Insolvency Resolution Process, IRP or Interim Resolution Professional is appointed, and once the Interim Resolution Professional is appointed, he he or she they constitute a committee of creditors. Committee of creditors is only of the financial creditors, and then they decide how to go further. So the committee of creditors, it actually starts taking the decision how to restructure the company, how to come out of a debt, what are the best resolution plans which are applicable. Now coming on to PIRP, in PIRP you have a phase 3. Now under phase 3, sorry, Mr. Balasubramaniam, the members of COC are financial creditors like your banks. See, I will be teaching you IBC also. In IBC, you have financial creditors and you have operational creditors. So your financial institution like banks etc., they will come under the financial creditors, while your supplier of a say cement or raw material or even the workmen, so one who supply goods and services, they are known as operational creditors. So they have got the financial creditors available only are part of the committee of creditors. So here when we will do our course, I will be telling you about voting shares. How do you calculate the percentage? Who can vote? And is it just the numbers of person, or is it by way of how many people that are there, the value of the shares that they have given, the or the amount they have given in the default, that will constitute. Is individual depositors of company are also COC? They can become part of COC, right? If you are talking about that you are a depositors, but there is a series of cases, like when there was a case of home buyers, it started with JP Associates, so JP Infra, sorry. So the question was whether the JP home buyers, they will be financial creditors or operational creditors. So there was a lot of decision from NCLT, and matter went to the Supreme Court also, though under Article 32. They said that as far as these home buyers are concerned, they are not financial creditors, right? They have not given loan to the company, but they have given a certain amount of money to get their homes ready. Then the question was, are they operational creditors? So the answer was clear no. But coming on to the individual depositors of the company, then yes, they have, if they have given it as a loan, then it can be, they can be termed as individual depositors. They can become the part of COC. Now, generally speaking, individual depositors, they don't become part of COC because their deposit amount is very less. Like banks have given loans in terms of crores, right? So your voting share to the default will be negligible. So in effect, they don't become the part of COC. I hope I'm able to answer your query, right? And now thereafter, I will move to the next part. I have told you about phase A and phase B. Now coming on to the phase C. Now, once the insolvency resolution plan by PRP is approved, it is submitted to the NCLT, which is the adjudicating authority, and you have got 90 days for its implementation. Now, this plan can be accepted or rejected by NCLT. So, in all, it is a game of 240 days. If the company which is under PIRP, the plan is rejected, then it goes back on its olden ways. Nothing more can be done, right? It does not go into liquidation unlike your CIRP. Now, with this, so this is essentially the preview that I wanted to give you of PIRP. Then, just to tell you some more thing about PIRP, you will realize that PIRP is not related to uh, uh, is not related to your resolution plan. Like in CIRP, you don't have to call. First, they give you a predetermined, a predecided plan, which is your base resolution plan, right? So first you receive your application for initiation of your PIRP. Now, if you look at the various timelines, just like CIRP, there is a 14 days timeline for the receipt of the application. The adjudicating authority, it has got this time to admit or reject, right? Then, just like CIRP, you have got 7 days to clear it. Now, the most important thing that need to be remembered is that all the time, right, the management of the company of the corporate debtor, it continues to vest in the board of directors or partners in case of LLP, right? Likewise, within in 2 days of commencement of PPIRP or PIRP, the corporate debtor, he has to submit to the resolution professional. They check out all the creditors which are available on the books of record, and then he forms something known as PIM or Preliminary Information Memorandum, which contains all the information about the resolution plan. Now, once the PIRP is done, so either you have selected the base resolution plan of the company, or you go and select BAP or best alternative plan, which is been submitted by other members of the committee of creditors. So if it is taken by any of these parties, then the company's issues get resolved. Otherwise, it gets ended. Now, one very important thing that you need to remember is that if the PIRP is not resolved, then you cannot opt for another PIRP within in 3 years from that date. So this is basically a broad outline, a very broad outline of PIRP. In our course that I will be teaching you, I will be covering your company law as well as insolvency law. Under the insolvency, I will be giving you about the basics. I will be starting with the fundamentals of the insolvency and bankruptcy code. Thereafter, I will be taking you to the fast track insolvency, pre-package insolvency, cross-border insolvency, and how the insolvency ecosystem is making our uh, economy back into track. If you look at the ease of business index, India has jumped not one or two or three, but 67 places because of this one piece of legislation. So this is what it is from my side on PIRP. And just to tell you right now, we have got few cases which have actually come before NCLT for adjudication on PIRP. So the first case came sometime in September 2021. So, if you have to advise your clients, I think this is a good method to take recourse to for resolving this distressed assets or distressed companies. So now I'll open the floor to for you to the questions. If you have any queries, please ask. Yeah.
Am I
So,
audible?
Mr. Prithviraj, what I'll suggest is that you should go through the amendment which has been made regarding the prepackaged insolvency, whereby Chapter 3A has been inserted in the code, in the Insolvency and Bankruptcy Code. It will be helpful if you read the legislation. It is a small code of uh, 16 sections or so. I can share you with some reading materials that you want to read, but essentially speaking on PIRP in particular, these reading of these sections will be enough. And if I talk to you generally about insolvency and bankruptcy code, I don't know you are in which year or you are a practicing lawyer. I suggest that you read the judgment of Supreme Court in Swiss Dipples. So that is one judgment that will give you a lot of clarity regarding the insolvency and bankruptcy code per se.
Also, just to add on to what Dr. Charu has said, all of these readings would be systematically would be found at our LMS, which is at the ebclearning.com as soon as the course goes live on 15th. So you will be able to find those readings, books, and even video materials, which is also being done by Dr. Charu Mathur. So you would be able to build some of your basics and the theoretical understanding, and then the class can also be helpful.
Yeah, so thanks, Pradyuman. So as far as our IBC course is there, now we are running it into the third edition. It is launched quite early, I think in 2017, yeah, 2018, then 20, and now a new edition is already there on the basics of insolvency. In this latest, I have added a chapter on pre-packed insolvency also. Apart from that, you will also be offered our course on the practical aspects of insolvency and bankruptcy code, as well as I'm trying to record certain cases for you so that you can read those cases and which can be helpful to you, right? And for as Mr. Pradyuman has just let us know that he will be making available all the reading materials on our website, and we have tried to make a complete ecosystem for you. So you will be getting your ebooks, you will be getting SCC judgments, you will be getting the Bear Acts, and if you feel there is anything else that we should do, we'll be more than happy to help you out in whichever way we can do. So, any other queries? And just to come on the body of the case laws, we don't have much case laws on PIRP per se, but as far as your insolvency and bankruptcy code is concerned, there are a lot many cases which have come. So when I started initially with the insolvency and bankruptcy code, uh, we had just the judgment of innovative when we recorded our first case, first edition of IBC, and yeah, today we have got the entire body. The jurisprudence has developed. There were many lacunas within in the grammatical errors within which were within in this IBC code which had come. So it is an important piece of legislation which we need to understand. Then one more thing aspect that will be which as such we won't be covering, but I will be just be touching upon is the group insolvency. There is a query from Mr. Prithviraj. He's saying, "Ma'am, I am moving from criminal law to corporate and would like to be prepared with basic terminology at the yeah." So if you are, if IBC is new to you, my suggestion is like if you are into practice, you can just read the Bear Act, because nothing gives you, in my opinion, better understanding than the Bear Act. Further, if you want to understand, there is entire uh, judgments of Justice Nariman on IBC that give you absolute clarity with a bit of history. It traces how it actually came into being. So you can start reading innovative industries, you can start reading Swiss ribbons. Once you read Swiss ribbons, many things will be clear. Then it is, you can also read about SR case, which was a landmark case as far as insolvency resolution process is concerned. Then you will come across section 29A of the Insolvency and Bankruptcy Code, which was again introduced midway during SR so that the existing management does not take a back entry to the company. So the rulers of SR, they had to be ousted from their own company. They tried to enter through a related party, but the government brought a legislation introducing Section 29E. So since I will be taking company law with you also, so I will be taking the fundamentals of the company law with you. And in
Am I
Mr.
audible?
Paras, yeah,
Am I
yeah, yeah,
audible?
yeah,
Sorry, I had some difficulty moving around that position where I can speak. You were mentioning about this is only meant for MSME sector,
yeah,
those which are registered under the MSME Act per se.
right.
Uh, are there any thresholds even in MSME in terms of the amount of debt that would be subjected for reconstitution or the resolution process?
So the debt has to be minimum of 10 lakh rupees. That should be there. And two, how do you prove that you are MSME? So for that, you have to, along with the application that you move for PIRP, you need to attach the basic certificate which is governed under MSME, and it is known as Udyam Registration Certificate. And in case it is investment in the plant and machinery or equipment, then you have to provide for the same. And in fact, from the income tax returns, they can find out what was the whether you are able to meet the requirement under MSME or not. So Udyam certificate is essential whenever you move your application.
On a related note, you earlier mentioned that the course organizers will publish the either the reading material or your presentation material as you continue through the course. Is that,
Yeah. We will be doing that. We will be giving you the reading material, interesting cases, or whatever the update is there. As you are aware, within in this course, you will be getting 15 odd ebooks that we have on corporate law with us. So
okay.
you will be getting access to that. Even the judgments which are available for SCC online. So whether they are of tribunals or whether they are of the high courts or supreme courts, whatever it is, that will be make available to you. And we are always open for any feedback. Do let us know. We would like to help you to the best of our abilities. And if you think that you need some more material or something, we'll be more than happy to provide, provided it is within our reach.
What would be useful for some of us in the practice is if you share your practical experience of the kind of challenges we face when we go through this kind of processes in any companies, not necessarily documented anywhere.
Right.
Simple issues may pose challenges.
I'll give you
Uh,
the one which I myself faced. So there was this case which I had to file in NCLT. I had to file in NCLT Chandigarh. Now this was a case of collective investment scheme. You know where these people will float a company and they say that you take these policies and we will give you a tree will be there or a livestock will be there. So I had some of those cases. Now the problem was that the person who floated the company, he vanished. People he put in were his drivers and peons and all those persons. So you cannot actually recover anything from them. Now the interface between the ultimate investor and the company was the agents. So the agents, they also invested their money in this project, and they also asked their relatives, friends, or for the commission to get involved. Now first challenge was making the petition itself. I had to get affidavit because there were thousands of these people to make that reach the threshold limit of 1 crore rupees. I had to get so many people to contribute them. Second difficulty was not everybody can be petitioner. You have to have a power of attorney in favor of one. So that was again a challenge to get 1,000 people to get a power of attorney in one person and getting them executed individually. Now the next thing that the challenge that we are still facing is how do you get them into the definition of financial creditors?
Creditors.
So yeah, he says that even when the payment company was running, the payment always used to go through the agents, the interface which was there between the investor and all. Now the NCLT says if you get affidavit from all the investors, which are must be into thousands of crores, thousands of 10,000, sorry, not thousands of crores, which will be running into at least lakh 2 lakh persons. Now it is impossible for anybody to get those certificates, affidavits saying that you give money to this XYZ and he will transfer to us. So these are few of the practical challenges that we face. Thereafter, other challenges to talk about is filing the appeals before the Supreme Court or NCLAT. Right, I remember in the initial days we didn't used to get the judgments properly, and the judgments which used to come uploaded on the website, they used to be of such a big size, and at that time we were not aware that you can compress them also. Right, pandemic was not there, so we were not aware that you can compress a PDF. So this was some of the practical difficulties that we had come across. And apart from that, there have always been challenges as how do you interpret the various terminology. Like I remember, I think it was the case of personal guarantor in K. Vijayakumar. So in that case, it was said that you can always proceed against the personal guarantor, right? Not if there is a moratorium against the corporate debtor, still you can move against the personal debtor. By that time, it was not available as a piece of legislation. It is only subsequently it was added. Then another practical difficulty we said ki we have moved, but now we don't want to proceed against this corporate debtor because he has paid our dues. There was no provision of withdrawal which was available under the code. It is only subsequently. So this is a piece of legislation which is already organic in nature. You come with a problem before the court, and then they were giving you the solution. They were tweaking. So yeah, that was an issue.
Interesting. Thank you.
Yeah. Sir, you are practicing lawyer?
Yeah, I'm a kind of a second profession practicing.
Great, sir. Where are you placed?
I'm in Bangalore, madam.
Great, great, sir.
Because we see some interesting newspaper items. Many times we wonder how they do. One important public project, I don't know whether it qualifies for a MSME or not. I don't know the company structure, called Simplex Infrastructure. They were building a flyover. It's running into many years and delays, and now they are declaring them to be bankruptcy, and then they don't know what to do. Project is halfway done. Citizens are affected
Right.
hugely. It's a Calcutta company. I don't know the much detail, but whatever I read in the newspaper, I'm just sharing. Under such conditions, this kind of making any provision to enable the company to continue, or what is the next mechanism? So one gets stuck in such cases in large projects.
So the best alternative is to take them for under the main IBC, not under PIRP, but under CIRP. Then at least somebody with the better managerial quality capability can do these projects.
Correct.
So that is. And another personal difficulty that I have faced, which I would like to share, like I appear for the commercial taxation department of certain states. Now the problem is invariably as a state government authorities, we come to know about some IBC case being filed as the last resort, the officers. Right? So we are never able to get the claim. So my question will always be that you have the debt available on your records. You know that these are the cases going against you. So you should take out the time to file the cases against, or to keep our debt also in your record. Then I was helping one of these IPAs, which is your insolvency professional agency, in the ethics part, because you have a paper on after you clear your exam as IRP, there is some training and you have to do a paper on professional ethics also. So there also it is very difficult to imbibe that it is entire responsibility is put on the IRP and RP in the insolvency professional, and how important is his or her integrity to the system. So many people were not aware of that key what this can be done. But you have to actually hammer into them that this is wrong. If there is any conflict of interest, you have to tell them forthwith. So these are some of the experiences, and now in South, you're lucky that NCLAT bench is there. Otherwise, everybody had to come here.
Yes, that's true. At least thanks to that NCLAT, now we have some close by access for an appellate tribunal.
And I was fortunate enough to appear before NCLAT Chennai because of video conferencing. Otherwise, I would not have come there.
How was your experience with the video conferencing
It is
deposition?
very nice. It was very good. It was moderated well. But only thing was that sometimes I was not able to get the link. So, but the lawyers from there, they used to provide me. And even otherwise, I am big fan of video conferencing or hybrid mode at least.
Now, Supreme Court also provides video conferencing.
Yes, we are still doing it. So Mondays and Fridays now, still on request you can get it. But Supreme Court has performed marvelously with video conferencing.
Yes,
So
lot more than many high courts.
yeah, we experimented first with the app called Video, VIDYO. Then we tried, ultimately we shifted to WebEx only, Cisco WebEx. So that was the most helpful.
Thank you for your overview today, ma'am. Look forward to your actual course as we
Yeah,
progress.
looking
Learning.
forward. Right, right.
Any other questions? You could step onto the loudspeaker spotlight and can ask Dr. Charu any of the questions, even future and regarding the course framework, especially in terms of the classes related to insolvency is concerned, that how we are going to build that part up. So any of the questions, although these classes would be in later half of our course, but any preliminary questions or inquiries are most welcome.
On behalf of many participants, Mr. Pradyum, I have one general question. Since we have already done 3 or 4 this preview classes, now we are already the 11th of April is over, and you are starting the regular course on 15.
Right.
Would you be sending us a kind of a constant login credential so that we don't need to
Yes.
wait every day for this?
Yeah. So Mr. Balasubramaniam will be making your profile on a learning management system. And there, all the videos, readings, the access to permanent link would be available all at one place, including the ebooks and the access to SSC online links. So all of that would be present at one place, so you don't have to go to multiple locations to access them. So the because it is automated, so you'll get that access automatically. I think the 15th we are beginning, so 14th midnight it would automatically appear when you will be able to log in. And the people who have already enrolled here, for example, Prithviraj and Mr. Balasubramania and also Shubha, I guess. So we will be starting with an introductory questions. We'd be having conversations regarding our mutual expectations from each other, and would like to build a good system. And there onwards, we'll be introducing to the learning management system. How do you use it? How to access it? It's pretty much simple. It's just like, you click on it, the videos will play. You know where the live classes would be, the readings would be listed there, the books icons would be listed there, in the index of cases, the cases would be there. So it's all single click basis. So it will be all comprehensive in that. These classes were conducted via email because these were open to all the people, so that we can have larger participation, and people who want some sort of a sneak peek into what is coming into the real course and how we are doing it. So that is what these classes were meant for. Also, if people who are attending this session was a bit of an advanced level, and even if their basics in insolvency are not clear, this nothing to worry about. We have a host of videos, the book assistance, other materials, and while we are doing the classes, we are taking everyone from the basic level to the advanced level. Right? Today was just only the general overview, so that's how we planned all our complimentary preview classes from different areas. Some of them were basics, some of them were advanced, for example, in M&A strategy class, or let's say today's class, and some of the elementary classes on limited liability. So if you have any questions, I'll be hanging around here. I'm at the May I Help You desk. Everyone or whosoever wants to have any other questions, please visit me. Um, that will be all. I think on that note, if Dr. Charu may have to add something, otherwise we are done with it, the session.
Thank you.
Thank you, Pratibhan. Looking forward for our full course. And as always, if there is any suggestion, we are more than be happy to help you in whatever way we can. Thank you.
Okay, ma'am. Thank you.
Thank you. Good night. Take care.
Good night. Bye.
Bye-bye.